Thank you for joining us. Today I'm joined by Alex Taghavi. He's a personal injury lawyer with our law firm, Iacobelli Law Firm. Alex originally started with us when he was a student, worked for us for about a year as a student, and then he went out and got some experience and recently joined us again as a practicing lawyer in all personal injury matters. Alex, welcome.
Thank you, Andrew. It's always a pleasure to be here.
Why don't you share with us a little bit about your background? I know your education was a little bit different than most, the route that you took, so share a little bit about that.
Sure. So after high school, I decided to go to the United Kingdom, where I studied at the University of Kent. And that was a 3-year program for law school. Upon completing that, I returned to Toronto and embarked on a master's program for internationally trained lawyers called the Global Professional Masters of Law. And then upon completing that, I met Andrew and we hit it off, and I commenced my articling term as a law student.
Somewhere in there, you took a negotiation course.
After getting called to the bar in May of 2024, I completed the Harvard mediation program. They gave me a lot of insight on negotiating and mediations.
So in a relatively short time, Alex, I'd say you got a pretty well-rounded education. You studied in England, studied in Toronto, and then you studied in Massachusetts.
Certainly. A lot of experience and a lot of great network along the way.
And Alex brings that to us, and he's been a great asset on his return to the firm. So today, Alex and I, we're going to talk about negotiation and how we negotiate cases on behalf of our clients, whether it's a car accident, motorcycle accident, premises liability, or any other injury claim arising out of negligence.
With that, I think we should discuss the approaches we typically take towards a file and how we engage the other counsel and build their interest in negotiating with us.
So I view the entire process from the moment we are retained as the negotiation. The negotiation starts the minute we get hired on a file. And everything we're doing, all the steps we're taking are to put us in a position where I'll say to give us the leverage or put us in the best position to negotiate our client's case for a fair resolution. Statistically, many cases settle. The vast majority of cases do settle outside of court, meaning outside of a final verdict. People estimate that statistic to be somewhere upwards of 90%. But where it settles really depends. And so the negotiation is that entire process leading up to the ultimate resolution if it's a case that settles outside of court.
Right. Now, a key word you noted was fair. How do you find an objective number, for example, in order to insist on a resolution with the defense counsel?
Yeah, it's a good point. So it's a point I make to clients right at the outset. So oftentimes, sometimes the first or second conversation you have with a new client, they say, so do you like my case? Is it a good case? How much do you think my case is worth? You know, I regularly tell clients, I cannot tell you with any precision right now what I believe your case is worth. I have an idea of what it may be worth, what it could be worth, but ultimately I'll educate the clients and I'll say, look, in this type of case or scenario, so let's use a personal injury matter, there are damages, certain categories of money or compensation for your harms and your losses that we can seek to recover. And then I'll break it down for them. And I'll say, okay, well, everybody's heard of pain and suffering or general damages, non-economic or non-pecuniary losses, economic losses. And as you know, the big ones there are healthcare expenses, housekeeping and home maintenance. The other big one is wage loss. Those are the categories that we just can't guess what they're worth. You actually need the opinions of experts. You need an economist. You need a vocational expert. You may need future cost of care analysis done so that you can quantify those numbers. That's what I would tell any client is we don't know at the outset exactly what the case is worth, but if the facts support that those losses exist, we will investigate it. We'll invest the time and the money to tell your story, hire the right people, and quantify those losses. The hammer we hold, so to speak, is the ability to go into the courtroom and finally have a judge or a jury resolve the case and answer those questions. As long as you continue to develop the story and shine the light on the evidence that supports your case or supports your client's case. If your reasoning is sound in terms of how you come to your numbers, most of the time, the insurance company, as you get closer to that trial date, tends to back off of their sometimes hard-lined defense posture. That's been my experience generally.
When the pressure comes forward, the defense will probably take a step back and look at your case for what it really is worth rather than what they want to settle it for.
Yeah, it's easy at the beginning for the insurance company to make a really lowball offer. Why wouldn't they?
Right.
There's a lot of lawyers, there's a lot of people unrepresented that might accept it or maybe accept, slightly above what they've offered. The insurance guy's got every incentive in the world to throw out a lowball offer because if you say no, big deal. And also there is no looming trial date. It's much harder to give a lowball offer and then be facing a trial in 2 weeks.
Right.
And you have to back up that position in front of a jury.
Right. How much of a trial is built on advocacy and persuasion?
I think it will go beyond the subject matter here, but it's a good one we could do. I'm a fan of trial lawyers. I follow trial lawyers. I think that some of the most exceptional individuals in our society, they have made the world safer, particularly personal injury lawyers and product defect lawyers. And unless you're a lawyer, you probably take for granted, unless you're a lawyer in this space, you probably take for granted all of the safety things that exist in the world
As a result of
litigation, whether it's vehicle safety, product safety, bicycle safety. We've seen it in just about everything. It often has come from these trial lawyers. There's different theories on what it is to be a good trial lawyer, but the one that resonates most with me is the just be as authentic as you can, be yourself. If you're not, the jury will see that.
And going back to the topic of negotiating, I'm sure having a reputation of being a solid trial lawyer assists you in the negotiation process, right?
There's no question insurance companies keep statistics on everything. That's their business.
Right.
Their business is setting premiums based on risk. A factor in a case on what the risk is of going to trial is undoubtedly who's the lawyer representing the injured party. And if you're a lawyer that always settles cases, if you're a lawyer that always takes the last best offer at mediation, if you're a lawyer that never files suit, they know that. You can't hide from that. If you're never going to file a lawsuit, or if you're never going to go to court, or if you're always going to settle for the last best offer they make, I think the insurance company will just continuously, you've heard me say that in the office for sure. If you settle that case at mediation, you're going to get a reputation, and the next mediation, they're going to offer you a little less, and the next one a little less. It's also very important to make sure that we're not too predictable in terms of the insurance company. And I think it's easy not to be predictable if you are advancing a case for the right reasons.
Right. Now, in certain circumstances, clients are eager to want to settle the case. And of course, as a lawyer, you have the insight of the legal process. And you understand what a case has potential for. When negotiating, what's the best approach to client management and trying to get the best out of your case?
That's a great question, actually. Yeah, clients do want to settle their cases. And that's surprisingly, if you were in that situation, you wouldn't want protracted litigation either. So it's understandable. It's completely understandable that they want to close their case. The insurance companies know that,
Of course.
That's why insurance companies, one of their well-known tactics is the delay, deny. Delay, deny, defend. It wears people down. They know that people want this case closed. If they're worn down enough, they might take less, sometimes substantially less than what a case is worth. Managing the client, I think, just comes down to being honest with the client, educating them, explaining that to them. I do remind clients at the end of the day, it is your case, and I'm going to do what you want to do. And if you tell me you want to settle your case, even though I might think it's worth going forward, and even though I'm telling you I think we should go forward, it's your case. And I understand there's more, sometimes there's more to settling a case for a person's mental health and just the ability to move on than just the money. So I'm always clear with that. I think it's just educating your clients, explaining to them the process, explaining that we've been down this road many times. Many times. It's their first time through this, but we've dealt with this insurance company. Maybe we've dealt with that defense lawyer. Maybe we've even dealt with that adjuster. We've been down there, and we're very confident that if they just continue on this path, things will work out.
Right, right.
That's really the only way I've ever been able to manage expectations and manage the clients is keep them informed on the reasons why we want to take the step we want to take.
For sure. Transparency and always keeping them in the loop, right?
Well, on these important things, like if it's settle or don't settle, you definitely want to explain to your client why you think it makes sense not to settle at this point in time. Or maybe it's a situation where it does make sense to settle.
Right.
And you're telling them it makes sense to accept that offer. I find that comes up less frequently. It's usually the other way around. It's usually us trying to explain why they should not accept the offer. But occasionally we get to the point where maybe there's problems with a case or challenges that the client doesn't understand that we think won't necessarily play out well in front of a judge or a jury. And so you have to educate them on why it makes sense to settle the case and avoid having it tried in front of a jury.
Oftentimes when client expectations are too high, right? As you just mentioned.
Sometimes, yeah, I find that less frequent.
How does that affect the negotiating process with defense counsel?
You know what? It maybe slows it down. I'll educate the clients on what I think it's worth. But if the client wants to start higher than what I think makes sense, I'll tell them, well, I can't justify it. And I'll explain it just the way I did earlier, the harms and losses. So let's go through the heads of damages. Here's what you can expect for pain and suffering. This is what the courts or the juries are awarding in similar cases. Sometimes you need the help of a mediator if your client's expectations are too high. You know, you need a good mediator. Sometimes you need a pretrial judge.
Right. An additional insight.
Yeah. Sometimes we'll have meetings, multiple meetings. Let them think about it. Oftentimes there'll be more than one lawyer on that meeting. They can get different points of view from different lawyers from our office. If it's really necessary, although this is rare, you know, sometimes there may be a disconnect. And in those rare, very rare circumstances, my suggestion to the client will be, why don't you speak to another lawyer, independent of me, independent of my firm? There's plenty of good lawyers. I can give you some names and you can get a second opinion.
Sure. Yeah.
And that's worked in the past too, because if I think it's a fair resolution and the client's expectations are too high, I'm pretty confident that they could go to pretty well any other lawyer practicing in that geographic area or that venue, and every lawyer is going to tell them it's a great result. Like I'm that confident. But that's just because, you know, I've been doing this for years.
Right, right. Yeah, second opinion can always build your confidence back.
Yeah. What's your favorite part of the negotiation?
Probably building the case and opening up to the counsel on the other side and revealing to them my deck of cards and saying this is why we deserve X amount. Typically, the counsel won't immediately agree. It's in their nature as a lawyer to be right on their end. Nonetheless, we all, as lawyers, have to substantiate our claims. So with enough reason and rationale, the negotiation will be fruitful.
Yeah, that's true. That's pretty exciting when you take a position and the defense takes a really drastically different position and you just keep marching and keep sticking to it and keep sometimes supplementing with additional information that supports that position.
For sure.
And you just see them starting to crack, a little crack here and a little crack there. And before you know it, they're in your ballpark.
Exactly.
And you're like, thank God I didn't settle that case 6 months ago because nothing fundamentally has changed.
Exactly.
Other than time and pressure, and we're closer to a trial date. And now they're finally starting to concede those points. Yeah, that's a great feeling.
Right. They say time heals all wounds, right? So if you give it enough time and you build up the case a bit more, get them to see your vision, right? That's also why I think negotiation requires some form of rhetoric, persuasion, and advocacy, if you will. People think that's reserved for the trial, the court date, but that's really a day-to-day interaction with other lawyers. You reveal your understanding of the case, your ideologies, how you want to approach it. If they come to understand the vision that you have for this file, that's great. If they don't, then you got to keep working at it and obviously be creative. Adapt the mindset of the person in front of you, the other lawyer.
Yeah. And you touched on something really important, I think, which is preparation.
Sure.
Lawyers are afraid of lawyers that are over-prepared.
So if you're prepared and you know your case well, and not only knowing your case, but you know your client well,
Absolutely.
then that can give you insight that the defense has zero knowledge about. Because medical records alone can have no objective findings. But in terms of their lifestyle, their recreations, their leisurely life, they're no longer the same person. Their sanity may be off-put because of what they're going through. Not only because of the injury that they may be suffering, but also because of the long legal process that's ahead of them.
That's right.
And it can be very intimidating, which makes things a lot more severe on their end. But again, as their counsel, we have to comfort them.
That's right.
And guide them through the process.
One of the things we like to do is we work as a team and we like to share and talk and discuss. And we have regular meetings where we're discussing client files. If there's an aggressive defense position, we'll talk about that position and sort of brainstorm on how to build up the case to overcome that defense.
For sure. A lot of creativity is necessary, right?
I agree. And hopefully helps us get the best results we can for our clients.
Right.
Alex, thank you for joining me today with this. It was a fun conversation. I enjoyed learning more about your insights too into the negotiation process. And I know you're a fan of reading textbooks and obviously education and continuing to educate yourself. So this is just the beginning. I'm looking forward to seeing you continue to grow in your negotiation abilities, which are already quite strong.
Thank you, Edge. It was always a pleasure. And I'm looking forward to learning, growing, and building my craft here at Iacobelli Law Firm.